Hello, I'm attorney Dan Marr from the Nashua, New Hampshire law firm of Hamilton Kerrigan. I've been practicing here in New Hampshire for approximately 39 years, pushing on to 40, and in the Commonwealth of Massachusetts for about 30 years. I'm going to be talking today about promissory estoppel. This is something different than contracts, which I'll discuss in a moment, and gifts. So contracts, I've discussed this in other vlogs, you have offer, acceptance, and exchange of consideration. And then you can have a binding contract. There are some defenses sometimes to that as to whether or not certain contracts have to be in writing, other issues that I've dealt with in other vlogs. And that's in regards to the contract itself. Gifts I've done in another vlog is if you have donative intent, delivery, and acceptance, you can have an actual gift in those circumstances. But there's something that's different than both of those issues, not a gift and not a contract. It's called promissory estoppel. There are 6 situations upon which somebody makes a promise and the other side detrimentally lies to that, and it may not be an exchange of an offer acceptance and an exchange of consideration. It could be in a situation where somebody's been told, if you do this, I'll give you that. And the the consideration is it's not something necessarily valuable to. Happens a lot in construction bids. There could be a bid situation, and you could be in a situation where you actually make a proposal. It could be construction or other things where you make a proposal for a project. You want to get this business, and you say, "I'm willing to to do this," and depending on the circumstances, there might be an actual promise that the other side relies on, or maybe you're relying on the promise. And if there's detrimental reliance, there can be an enforceable contract, sometimes up to the value of the promise itself. So I'm going to go into that detail a little bit more right now. Basically, promissory estoppel is there to enforce promises underlying otherwise defective contracts. So if you have a situation where there isn't an exchange of consideration, because the other side just isn't going to get anything. They just said, if you do this, I will consider that. You may not have a binding contract. One of the things that I've seen using the term promissory estoppel sometimes is in regards to when people are making an offer to do a contract and they don't actually enter into a contract. So if you're being induced to do certain things to rise yourself up to the level of being able to bid for a contract, and they're telling you if you come in the lowest bidder or some other circumstances, we're going to do a deal with you. At some level, it might be promissory estoppel in that, and you got to be very careful. I myself, whenever I'm doing anything where I have a contract proposal, I will say something is not binding until we have a signed agreement or we have an exchange of an agreement. Because sometimes you might have in a situation where you might be providing services or goods and you provide a PO, a purchase order, and then they accept that purchase order, then you have a binding contract. But until that period of time, you want to have the ability to withdraw from that, and you don't want the other side to say, well, I relied on that. You gave me something. I didn't accept it, but I relied on that. So I suggest that you put in language that says it's non-binding. It happens a lot also in leases or sales of businesses where somebody's thinking about, I'm willing to buy your business and I'm making an offer, and you if I make this offer and you haven't actually accepted it yet, but you say later on, I relied on that offer and I went and did certain things in reliance on that offer, you want to make sure, if you're the one making the offer, that you put in sufficient language in there that says it's not binding until we actually enter an agreement. In a sale of a business, what you might do is you do a letter of intent, and that's let's make sure we're on the same page. So in a business, you've done your due diligence or some initial due diligence, probably had a non-disclosure agreement that's a binding contract. But then you looked at the documents and you say, I'm willing to buy your business for this, and this is what I'm expecting to get out of this. And if you're doing that and you're saying, but later we got to go to the devil's in the details, and the details are going to be in an asset purchase agreement later on, you want to do a letter of intent that says what your rough understandings are, and then you put in that's non-binding in regards to, there might be a provision in it that has an exclusivity period where the other side's not going to be looking for others to buy the business too during a short period of time to give you an opportunity to do the purchase and sale, but you want that. Same thing with a lease. In a lease situation, big commercial leases that I have, you'll have a letter of intent first, figure out that, and then you'll do a lease itself. And the lease is the more complicated issues, but you want to have the non-binding effect in that. So promissory estoppel is a possibility of a claim that can be brought when somebody doesn't have consideration exchanged. There's been a promise about that. The way, if you want to get around that, is you want to put very clearly in your proposals that it's non-binding and it's subject to a full agreement. So if you have any questions in regards to this, you can give me a call at 603-883-5501. Dan Marr, 603-883-5501. And this and all my weekly vlogs I've been doing for years now, you can go onto our website at Natural Law, all one word, naturallawis1word.com. Check my bio out. From there, you can get to my YouTube channel. Look forward to working with you if the opportunity arises. Again, Dan Marr, 603-883-5501.